Good day to you and welcome to another Paddocks video. Today I want to talk about dogs. South Africans are a nation of dog lovers. We like pets generally, but dogs are particularly popular. Many families have more than one. And they become like members of our family. But what happens when your neighbours and other members of your community scheme not only don't love them, but in fact want your pets to leave? It can be heartbreaking to have your dog labelled as a nuisance. You need to do something about it. You need to know what your rights are and what your obligations are, and then act sensibly to protect your interests. So what is the law on the keeping of animals, reptiles and birds? It's simple. You're not allowed to have them in the scheme unless you have the trustees' written consent. And the trustees, in giving a consent, can provide reasonable conditions. If those conditions are breached, they can withdraw the consent, which means that the dog has to leave. What sorts of behaviour are normally complained of? Well, persistent noise, especially barking, scratching, that type of thing, fighting next door, digging holes and causing other damage in gardens, chasing people, vehicles and other dogs, biting people, other dogs, cats and anything else, being off a leash, defecating on the common property, causing substantial damage to property. Often the first indicator that your dog is a problem will be a notice that you get from the managing agent or trustees, and hopefully that will tell you exactly what the complaint is, who has complained, so that you can actually deal with it. But let's just look at one's duties. Firstly, as an owner or occupier, you have to use and enjoy the common property so as not to unreasonably interfere with anyone else's lawful use of that property. You can't obstruct anybody else in their use, and the body corporate has an obligation to ensure that that is how everyone behaves. No one is allowed to make noise that impacts the use of the common property, and that includes dog barking or other types of dog emanating noise. Nuisance is something that's a very wide concept, but anything that unreasonably interferes with others' peaceful enjoyment of their sections, their exclusive use areas, or the common property generally is, and happens on a persistent basis, is nuisance, and that is outlawed in terms of both the Act and the rules. And finally, there's the disposal of waste provision, which says that no person is allowed to leave anything, which would include doggy-doo, on the common property or in an exclusive use area if it's a health hazard, which is likely to interfere with the enjoyment of other people. So what do you do in these circumstances? Well, you find out what the problem is and you take steps. You tell the trustees you're going to take steps and you take them. You talk to the people involved, apologize. It makes a lot of sense if you think that they have been inconvenienced. If, however, you think they've been unreasonable, then get legal advice. Find out what your rights are before going further. It's a matter of interest under the Sectional Title Schemes Management Act. People who suffer from a disability and who reasonably require a guide, hearing or assistance dog will be entitled to have that. Doesn't mean that the dog can stay even if it causes a nuisance, but you won't have to get permission to bring it on in the first place. There will also be a community scheme ombuds service in the reasonably near future, which means that either parties, corporate or owners, who feel that the other party is being unfair or unreasonable will be able to go there for a suitable order. Thank you for joining me in this video.